Hello friends, in the series on the income tax cases, today we will discuss a very important case on section 263 and section 143 subsection 2 notice. The name of the case is AK SANTHOSH versus Deputy Commissioner of Income Tax, and this case has been reported in 101 ITAT Tribunal at page number 581. The matter has been decided by COCHIN ITAT and the date of the judgment is 1st August 2022. The facts of the case are very interesting. The assessment year involved is assessment year 17-18. The moot question in this case is that when the assessment has been completed without issuing the notice under section 143 subsection 2, whether that assessment can be taken for revision under section 263 by the CIT or not. In this particular case, the assessee didn't file its return of income in the due time under section 139. The department issued notice to the assessee under section 142 subsection 1 because there was a substantial cash deposit into the accounts of the assessee. And when the assessee filed return in response to the notice under section 142 subsection 1, the department issued another notice under section 142 subsection 1 and did the best judgment assessment accepting the returned income. But the main flaw in this was that the notice under section 143 subsection 2 was not issued to the assessee after filing the return of income. The assessee gets the favor because the assessee's returned income was accepted. But when learned Commissioner of Income Tax was analyzing this assessment records, he observed that this order is erroneous and prejudicial to the interest to the revenue in accordance with section 263, and he initiated the revision proceedings under section 263. This matter was before the Honorable ITAT, and the assessee was contesting the point that this assessment has been completed under section 144, that is the best judgment assessment, without issuing the notice under section 143 subsection 2. The assessee was relying on a very important judgment of Supreme Court in the case of CIT versus Hotel Blue Moon 2010, and this case has been reported in 321 ITR at page number 362, in which the Supreme Court categorically said that any assessment without issuing the notice under section 143 subsection 2, where the assessee has filed the return of income, because notice under section 143(2) can be issued only when the assessee has filed its return of income. If the assessment has been done without filing the return of income of the assessee, then there is no requirement of issue of notice under section 143 subsection 2. But in this case, the assessee filed the return of income in response to the notice under section 142(1), and after filing the return, the assessment was completed by issuing the another notice and asking the information under section 142 subsection 1, and best judgment assessment was done. Since the original assessment without issuing the notice under section 143 subsection 2 was null and void from the scratch, so an assessment order which is not valid in the eyes of the law cannot be revised by the learned Commissioner of Income Tax under section 263. Friends, this case is very important. Sometimes it happens that we are very weak on the merits. But when there is a substantial requirement in the law on the part of the department to issue some notices, and without issuing and without following that procedure, the department does the assessment of the assessee. So sometimes it happens that in that assessment some additions have been made. So even that assessment will be null and void. By chance, in this case, no additions were made in the assessment, but the CIT opened the revision under section 263. So the assessee took a very valid point, and 263 proceedings were quashed on the point that the original assessment was completed without issuing the notice under section 143 subsection 2. That is why that assessment was null and void, and so that assessment cannot be revised under section 263. Friends, this case is very important, and this case has been reported in 101 ITR Tribunal Act page 581. The matter has been decided by Cochin ITAT, and the date of the judgment is 1st August 2022. Thank you, friends.